So welcome everyone, those being here with us today and those joining us online. We're very glad today, on behalf of the Bonavero Institute of Human Rights, to have with us Jennifer Gordon, also Sophia and Mayan in this event. So without further ado, because I'm a bit under the weather, I'm going to give the floor to our panelists, that they will speak about the event a bit more. Thank you.
Yeah, just a bit of housekeeping. There's some face masks on the table because we have some people a bit sick from different illnesses, including a bit of COVID. So if you want, the face masks are there.
I'm heading to the ventilation.
Exactly, that's a good strategy. Yes. Welcome. We have Murray Hunt, Director of Modern Slavery PEC, just joining us. So thank you everyone as well online. I didn't know I was going to be the one presenting everyone, but I'm happy to just introduce myself really quickly. So my name is Sofia Gonzalez. I'm a research leader in business, ESG, and modern slavery. I'm based at the Bingham Center for the Rule of Law and undertake research for the Modern Slavery and Human Rights Policy and Evidence Center, MSPEC for short. And we're very excited to have Jennifer Gordon joining us today to speak about one of her most recent papers on the US forced labor import ban. And before I turn into Jennifer, I would just like to give a brief overview of forced labor import bans and the work that we will be publishing in the autumn from the Modern Slavery PEC. So we are updating an analysis of the effectiveness of forced labor import bans. We undertook the first analysis in 2021. So you will see the update in 2024 in the autumn. And, this is a key, quite important topic at the moment. We know that the US is the one with the most mature import ban regime in the world, but we're also increasingly seeing other countries developing this type of regulation, like the EU, who recently, earlier this year, formally adopted the forced labor import ban in the EU. And we also have Canada with the new legislation as well, the Act. And well, just a brief statement on what are we talking about here. So forced labor import bans are domestic regulatory frameworks developed and enforced by states to restrict the imports of products on the grounds of suspected forced labor in their production at some point in the production of these products. And this is only one of the several tools that states have to address modern slavery and global supply chains, in particular in terms of third countries' influence. So what are we looking at in the Modern Slavery PEC update document? We're looking at the effectiveness of these tools, and we see the effectiveness in three ways. So the first type of effectiveness is to what extent these import bans avoid the entering of products made with forced labor into a market. Also, to what extent they change business behavior as a result of these tools, and government behavior, because we also see that governments in third countries change their behavior as a result of these import bans. And very interestingly, we also see anticipatory effects, which means that regardless of whether the measures are imposed or not, the threat of it or the realistic possibility of having their products restricted from entering a market has an important effect in businesses and governments. And that links very well to what Jennifer will be discussing today. And also we will be looking at the unintended consequences of these bans, in particular unintended consequences to vulnerable people, So how these bans could negatively affect workers in global business supply chains. And there's obviously concerns as well about the extent to which these instruments are politicized, to what extent they are protectionist trade measures. So we're going to be addressing all of that in our update. And with that as a contextual information, I'll hand over to Jennifer. Thank you so much.
Perfect. Thank you, Sophia. And thank you to the Bonavero Institute and the other sponsors of this event. So let me talk just a little bit to set the context about the US ban. The US actually, although this is a new hot tool, as Sophia said, the US ban actually has been on the books since 1930. It's been on the books, but it hasn't really been available for meaningful use. And so it was in 2015 that the US Congress amended the ban, closed a loophole, and all of a sudden the US government really had a tool on its hands that it could use. About 2018, US Customs and Border Patrol, which we call CBP, began actively enforcing the law. And between then and now, the agency has issued 40 orders to stop goods at the border. We call those withhold release orders, or WROs. Those are the only two acronyms I will use all day, CBP, WRO. And those orders bar goods on the suspicion that they were made with forced labor. 39 of those orders had come already by the end of 2022. Then we had a hiatus of 16 months, unexplained. It wasn't that the government said it was going to go on pause. I think the general assumption is that it stopped issuing new WROs because it was focusing on a new law that the US Congress had passed, the Uyghur Forced Labor Prevention Act, which also stops goods made with forced labor but has very different legal terms around it. And frankly, I think the agency was also focusing on pushback from industry to its enforcement of both of the laws. That silence was broken in April with the issuance of a new WRO, relatively small, not actually forced labor, it was a prison labor WRO, and we don't have any sense from the agency on where it's going next from here. I should also add that although the law does not require, and this is an important and also unfortunate from my perspective point, the law does not require a remedy for workers as part of remediation of forced labor. That is to say, CBP can lift one of these orders if it finds there's no more forced labor at the company without ever compensating workers. And in fact, CBP often does that. And in fact, CBP often goes through the whole process without consulting workers affected by forced labor at all. In some cases, CBP has pursued compensation, and it recently announced that overall it's collected $200 million in recruitment fees paid back and back wages for workers under this law. So we've now had a chunk of time for advocates in the United States to gain experience with the law. They've filed scores of petitions with CBP, also advocates outside the United States as well. CBP recently said it had 65 petitions pending. So if there haven't been recent WROs, it's not for a lack of petitions in the queue. And advocates have also interacted extensively with CBP about investigations and enforcement. And on that basis, advocates have critiqued CBP's enforcement approach from a human rights perspective. Just to very quickly highlight the top line of those critiques, they include that the agency is very slow and, in fact, as I said, stopped issuing orders for a long period of time, that the agency isn't transparent, it doesn't reveal what its priorities are or really give clear standards or timelines, that the agency has continued to rely on flawed social audits rather than investigations involving workers, although the agency is talking about a change in perspective on that front. And as I hinted earlier, that the agency doesn't always pursue any and rarely pursues a full remedy for the workers involved. But what there's been less of during this period is a critical perspective on advocates' own strategies in relation to the import ban. And the research I want to talk about today is my effort to consider how advocates approach this tool strategically in order to address some of the structural factors that lead to recurring forced labor in supply chains. And by structural, to be clear, what I mean is that forced labor in supply chains is not usually due to isolated bad actors. Instead, it recurringly arises from systemic pressure from brands and retailers at the top of supply chains on their suppliers at the bottom of the supply chains to deliver goods as cheaply and quickly as possible. And the suppliers have to cut labor costs in order to remain competitive in that process, and this incentivizes them to seek the most vulnerable and easy to control workforce, who often include migrants and others under conditions of forced labor. And so what I'm asking is, what are advocates doing already, and what else could they do to use Section 307, that's the part of that's the technical name of our forced labor import ban, in ways that have a systemic impact on this systemic problem. So I began this project just this fall with a series of interviews with the staff of the labor and anti-trafficking NGOs, mostly in the US, but also elsewhere, who often petition the US government to enforce these bans, to impose them, as well as speaking with the head of the CBP division in charge of the bans and others in government roles. And I then developed the analysis and framework for future work in the field that I want to talk about today, reflecting on not only those interviews, but also desk research and a review of often confidential documents and petitions that advocates shared with me. So let me talk a little to start about the ways that advocates have used the ban to date. The most common approach across the board, and I think it's fair to say this is also the agency's approach, is what I call direct service. And to be clear, these are terms, as I say in the report, and I believe people can access the report through the announcement of this event, that these are not the terms that advocates use. These are the labels I've put on these different categories. So what I call direct service is when advocates encounter a group of workers facing forced labor and they file a petition with CBP, and the goal is to get CBP to issue a WRO barring the goods made with forced labor. And the theory, the hope, is that the WRO and the remediation that CBP requires to lift the WRO is going to address the forced labor for the workers facing it, right? It's focused on alleviating suffering, which is very important. But I want to contrast that with what I call the strategic approaches. These are approaches that have as their goal, beyond and in addition to alleviating suffering, creating a systemic impact. And I divide them into three different levels. Approaches that target the top of the supply chain, the middle, and the bottom. And I think there are challenges and opportunities at each point. At the top of the supply chain, what I'm talking about here are advocacy efforts, petitions filed by advocates that name major brands and retailers consistent with the structural analysis that those are the entities that drive forced labor. And what they're asking CBP to do is to issue a WRO that names the brand or names the retailer. And the argument is that such a large percentage of that brand's imports of a particular commodity or good from a particular country are made with forced labor that all of them should be stopped until the company changes its top-down practices. CBP has never issued a WRO in response to such a petition. The agency interprets Section 307 as not permitting it to name an importing, right, the brand or retailer in the United States in a WRO, but only a supplier in the country where the goods are extracted, harvested, or produced. Advocates disagree on the legal analysis, right? They believe that aspects of the law do permit the agency to do this, but they haven't been able to persuade the agency to act on the legal theories that they've presented. Going forward, advocates think that the greatest chance CBP would issue a WRO targeting the top of a supply chain is where the corporate entity both controlled the brand and is directly involved in the production process, right? We call this vertical integration. For example, FCF Tuna is a Taiwanese tuna trader involved in the harvesting of tuna, in fishing for tuna in Taiwan, but it also owns Bumblebee, the tuna brand in the United States. So that's an example where advocates want CBP to do this. Firestone Rubber in the United States is a recognized tire brand, but it also, within its corporate entity, produces rubber in Liberia. Kaibo Chocolate, same thing. Brand, also involved in production in countries of origin. This is what advocates hope. There have been petitions filed on all of those fronts, but so far CBP has not responded. I should say that although this strategy has not succeeded in resulting in a WRO, there are definitely impacts for a brand or retailer if one of their suppliers has a WRO issued against it. So I just want to acknowledge that. But in terms of getting a WRO that names a brand, that has not happened. Moving to the middle. Strategic approaches that target the middle of supply chains are where advocates have filed petitions against major supplier firms in the country of production. And what I mean by this are firms that control a significant portion of the industry in their country, that are well known as producers in their country and have a great deal of economic power as a result. And the aim there is changing practices within that country and within that industry, in an industry where forced labor is common, and also provoking change in government policies in that country. Now, CBP does see major suppliers as appropriate targets and has issued several WROs following petitions that advocates have filed against big suppliers on a structural strategy. Malaysian palm oil, there are several WROs against big players there. Malaysian rubber gloves, a series of WROs in that industry. I would say that opinion is divided on the effectiveness of those WROs in terms of their systemic impact. Some have offered a positive assessment, pointing in particular to Malaysian rubber glove WROs, which sparked new industry and government policies and resulted in repayment of millions of dollars to workers. Much of that 200 million figure came in the Malaysian context. By contrast, others see this set of WROs as failing to bring about sustained change in the industry, and they highlight the failure to fully compensate workers for the harms that they suffered. Let me now turn to the bottom of supply chains, which I confess is where my core interest lies, and also is the most speculative part of this, because as I'll explain, it has yet to be tried, what I'm about to describe. This is an approach that would seek to use this same tool to support worker empowerment and organizing at the bottom of supply chains in conditions of forced labor. And here what I'm exploring is whether it would be possible, and if so, advisable, for a trade union or other worker organization to approach Section 307, the import ban, in a different way than the direct service and strategic advocacy at the top and middle approaches I've just described. So as far as I can tell, since the closing of the loophole in 2015, there have been no petitions filed by workers or their unions in the midst of an active worker organizing effort for the purpose of advancing that effort. Several organizations, I should say, have filed petitions in coordination with trade unions in the country and industry where there is forced labor. A couple examples, the FCF petition I mentioned, that was filed by Greenpeace in coordination with Indonesian migrant fishers unions. There was a petition in Irish fishing filed by an organization called Liberty Shared, which is no longer around, together with the International Transport Workers Federation. But in those cases, the goal was to open space for freedom of association more broadly, or to achieve the trade union's domestic policy goals, not to advance a particular worker organizing campaign. And this vacuum is not surprising. Conditions of forced labor and countries and industries where forced labor is common don't often lend themselves to workers being able to organize. And yet we know that forced labor occurs on a continuum. And while in some locations it's so severe that there is really no way for workers to act, and those of you who've read my report will know I set aside completely contexts of state-sponsored forced labor as generally such contexts. In other settings, while conditions still meet the definition of forced labor, whether because of restrictions on worker movement, withholding of wages, gender-based violence and harassment, among other indicators, workers have some more agency. And there have been a number of cases where workers have sought, or situations where workers have sought to challenge themselves, to challenge the conditions that they're facing. And I think in these settings, it's worth asking whether advocates or trade unions might use the import ban, Section 307, in a different way than the strategies I've outlined so far, with the goal of supporting those worker organizing efforts. And in particular with the goal of bringing brands and major suppliers to the table to support worker organizing. So because that's not part of our usual concept of labor organizing, right? Usually we think of labor organizing being about workers, their union, and their direct employer. Let me return for a moment to what I said about forced labor being a structural phenomenon driven by cost pressure by brands and major suppliers. This has implications for workers who organize with trade unions and supply chains. If a union bargains successfully with a factory or other company at the bottom of a supply chain for better paying conditions for those workers, that factory's costs are going to rise. And as a result, that company may no longer be able to compete. It might just not be cheap enough to compete for contracts from global brands. So if worker organizing in supply chains is to succeed, it's not enough for the union to bargain only with the worker's employer. The brands and the major suppliers have to come to the table as well. And these firms higher up the supply chain have to agree for the bargaining result to hold that they will put their resources into improving conditions at their suppliers and that they will continue to do business with the suppliers once the workers organize. Now, there are examples in the world of such accords where brands and retailers have made such commitments, but they've been, in general, very reluctant to do this. And the question is whether unions and advocates could turn to Section 307 to incentivize them to come to the table. So here's how it would look in a situation where workers whose conditions meet the definition of forced labor are organizing for better conditions. In those cases, the trade union or allied organization would consider whether Section 307 had the potential to be useful in this context. They'd have to ask whether there's no generic answer, right? Do these particular lead firms and suppliers have an incentive to stay and work through the situation? Or if a petition is on the table, or are they going to cut and run? Could the target supplier survive a WRO if one was imposed. Making sure also that the workers understand the risks and feel that it's worth taking them. Analogous, for example, to a strike vote, where workers decide to take those risks in the context of labor conflict. If the trade union decided to take this step after that examination, it would prepare a petition, just as anyone would, documenting the forced labor and the connection to the US market. It would tell the relevant brand and suppliers about the petition and maybe show it to them, but it would not file. It would hold off filing until the firms had the chance to negotiate an agreement, and only file if the firms refused to come to the table. In other words, the outcome sought here from the use of Section 307 would not, as with all the other strategies I set out earlier and all the other strategies in play at the moment, be for CBP to issue a WRO. And this is a really important difference. Instead, the goal would be to avoid the need for a WRO by concluding the kind of enforceable brand agreement I've just described in support of the outcome of worker organizing, in order to remedy forced labor in a forward-looking way through freedom of association. So, although it hasn't been done, there is growing interest in this in the United States today. And perhaps most importantly, for the past year or more, CBP itself has publicly endorsed what it calls worker-driven remediation of forced labor, which it has said includes brand agreements and collective bargaining. I have to say, though, in the interests of honesty, it has yet to put this into practice, and it has yet to explain what it would need to see in such an agreement in order to be willing to lift a WRO if one was in place. But the agency's position seems to be the result of the agency's experience following a particular WRO. So let me talk for a minute about that experience. In 2022, CBP imposed a WRO against an Indian garment factory called Nachi Apparel, which is part of Eastman Enterprises. So before the WRO was imposed, workers at that factory had been organizing against severe gender-based violence and harassment, among other abuses. And also before CBP issued the WRO, the workers had successfully and their union had successfully negotiated a collective bargaining agreement with their employer, supported by an agreement by brands and suppliers of the kind I'm describing. After that happened, CBP put down the WRO, and CBP says it was unaware of the set of agreements in place when it issued the WRO. But the result had the potential to be devastating. It threatened to harm workers who had organized and companies that had taken the risk of making enforceable commitments to those workers. CBP ultimately lifted that WRO in a matter of weeks, a record time, after advocates demonstrated that collective bargaining and the brand agreements had eliminated the indicators of forced labor at the factory. And since then, CBP has often mentioned these kind of agreements, alluding specifically to Nachi and that set of agreements as an example of worker-driven remediation. You could say, in a sense, that what I'm talking about or thinking through now could be described as Nachi in reverse. That is to say, the use of Section 307, not after, but before bargaining starts, to spur the negotiation of an agreement that would address the forced labor and avoid the need for a WRO. So that's CBP, which is a very important piece. Alongside CBP's statements, advocates, and increasingly, since I published my report, trade unions are interested in testing whether Section 307 could be used in this way. And in addition, it appears that some lead firms are beginning to see the enforceable brand agreement approach essentially as a potential source of insurance against the future imposition of WROs, which of course is very disruptive to business. I should say, if this starts to happen, it's going to be very important to have clear guidelines for what constitutes a genuine agreement with real worker engagement and real enforceability, because I fear the inevitable rise of agreements crafted and signed by firms to benefit firms without real meaningful trade union or worker involvement. So let me just end with what I think are two key takeaways. First, forced labor is, if you aren't sick of hearing me say it, a structural problem in supply chains, and therefore it requires a structural solution that places responsibility for addressing it on the economic actors at the top and middle of supply chains whose practices incentivize it. The tools we have on hand in the United States today are not designed with structural impact in mind. But advocates and in the future perhaps trade unions may be able to turn them to that goal with creativity and persistence. And number two, forced labor as a problem, to address it in a genuine way, requires the workers themselves to be a part of the solution. It requires interventions that offer workers at the bottom of supply chains leverage so that they can craft their own demands and see them through for the better kind of future that they want. And again, the tools we currently have at hand in the United States have not been designed with worker empowerment in mind, but creativity and persistence may also be able to turn them to those ends. Thank you. And I don't know if Mayan has been introduced or what order we're going in, but I want to call for an introduction of Mayan before she speaks. Are you next?
Yeah, I can introduce me.
Okay, introduce you.
So my name is Maya Niezna. I'm a lecturer at the University of Liverpool School of Law and Social Justice. And I think it was exactly 2 years ago that I was sitting here and commenting on a terrific thing that Jennifer just wrote. So it's a nice opportunity to do it again, and let's talk again in like 2 years or so and arrange another one of those. So the purpose of I have 3 comments, and the idea here is to start our discussion and provide some ideas for engagement. So I'm referring them to Jennifer, but I'm also proposing them to the room as some directions that we could continue with questions and comments, and I'll try to do them more or less in the order of the presentation and the report. And the first one, which I think is a really, really important thing that's reflected in some of the things you said earlier, and also in some of the things that Sophia mentioned in her introduction, was one of the conditions that Jennifer mentions in the report is for the organizations that initiate these proceedings, that they believe that filing a petition in this context is more likely to help workers than harm them, which is a huge challenge in basically almost all of the situations of forced labor. It's one of the ongoing challenges, and I want to invite questions and comments on that, and I want to link it to 2 issues that we see from concrete recent examples in the UK. One of them we've seen in a recent report by Embed Dignity on the Leicester garment industry, and one of the questions there was to what extent there was a big sensational issue around forced labor in small garment factories in Leicester, and there was enforcement of forced labor, modern slavery in the UK, responses to that, and there was a question of to what extent this worked. And the findings of this recent report were that while the situation was horrible, the outcome ended up doing more harm than good to the workers, because at the end of the day, these sort of initiatives are oftentimes they're not replaced by similar business respecting workers' rights or similar business offering better conditions. The businesses move elsewhere to a place that's equally, if not more, exploitative, and the workers remain without employment, which is a challenge for workers and for unions, and for those intervening in these sort of actions. And to some extent, we also see this challenge not just in the context of supply chains and production, but also in the UK, we see it with the health and care sector that is currently relying more and more on recruitment of workers from third countries. And there are lots of reports on massive violations of agencies, including charging excessive and illegal fees and not providing workers with work. Agencies lose license due to the violations, which maybe is a good response, but the result is that the workers remain in the country without the agency. If they don't find work relatively fast, they lose their permit and they're staying here oftentimes with massive debt, no work, and at risk of being deported, or some already being deported to their countries of origin. So for me, one of the interesting questions to discuss is how do different NGOs and unions assess the question of helping workers rather than harm them, and are there any tips or factors or ideas for ways to do that better in different sectors or generally? So this would be one thing. The other, and it links to something Jennifer was talking about a bit, to the notion of vertical integration and what these corporations are actually doing in different points across the chain, and the issue that there's clearly the problem of stopping the goods as a sanction, as a deterrence, and there is also a problem with remedy that is mentioned in the report. One of the things I was thinking when reading about it was the case of Nestle Vidal in the US, and basically the US Supreme Court refusing to allow proceedings of child forced laborers in cocoa farms in Ivory Coast, and no practical liability for the corporation for what? For transnational action, despite really important factors that reflect some of this notion of vertical integration, of this is massive brand name recognition that we see in chocolate we might not see in rubber gloves or construction material, and the fact that there was direct control and practically the sole purchaser from these plantations. So this was a very clear chain with a very clear leading that controls what is going on, and even in these situations there was no room for practical remedy. And one of the questions for me when reading this report, how remedy fits as part of strategic interventions, and are there ways from this particular example of import bans, are there also lessons to think more strategically around remedies and how they fit in the map? And the last one is this notion of the power of negotiating in the shadow of legal proceedings, or negotiating in the shadow of law enforcement. It's on page 25 of the report, and it's super interesting for those who haven't read it yet. And it's something that we see in other areas of law, the notion of the shadow of the law in both private and public law, as a way to get actors to the table and to get them to do something that the idea would be not as bad for them as what a court, or in this case a law enforcement agency, might impose, but good enough to make it unnecessary. And the notion that proceedings would not be filed unless the corporations, unless the actors would refuse to come to the table. And one of my questions here is how powerful and how frequent these orders need to be in order for this shadow of sanctions to be effective. And do you have some thoughts in terms of if these orders might be more frequent but less dramatic, or more dramatic but less frequent? Is there some sort of balance between where the effective threat of legal proceedings is? I want to finish with something quick about this notion of worker-driven that I think is super important, and I totally agree with you. There's a question of structural forms of exploitation, and we have to see the structures. And I think this term of worker-driven is really important for that. I think it's also important for the language that we use when we talk about modern slavery more often, because we're really struggling with the language that we use. Do we talk about victims? Do we talk about survivors? Do we talk about people with lived experience? And I think there's something really powerful with the use of the word workers, that we're not trying to delete anything else, but part of what's going on, the most important label, at least in this context of supply chains and production, is workers. And thinking about the people who are exploited in this framework of workers, I think it enables us to see some things that we might be overlooking with the language that reflects more notions of victims or survivors or lived experience that do not reflect and manifest this true nature of what is going on here is labor exploitation of workers, and it needs to be driven not just from the experience of people, but from the experience of these people as workers. So I want to thank you for terrific work on strategic enforcement that I think is definitely relevant for supply chains, but also relevant to various other contexts that we deal with forced labor. And I think we'll move to Christos or Sophia to manage the discussion from here.
I think we have a lot of very interesting questions and food for thought that Mayan has raised. So I don't know if Jennifer, you would like to start by addressing any of those questions, or if anyone would like to ask any questions. Would you like to?
Sure,
I think
very quickly.
Yeah, exactly. I think that would be good.
Let me say though, since you mentioned food for thought, that there's actual food for the people that I am embarrassedly eating my sandwich and I'm seeing no one else eating, so you should get actual food. With apologies to the people online who don't have that option. I really am looking forward to the discussion, and I don't know if Sophia or Christos, you also have things to say. So let me just very briefly start a response to the conversation that I hope others will pick up. Let me start with Mayan's last point about how frequent or how dramatic do orders need to be to create a shadow for the law and have it be meaningful. And I'll toss something out here, and I'm curious what other people think. I think it's less, actually, at this moment about the specific count of orders under this law than it is about the sense of which direction the winds are blowing in the regulatory climate more generally. And I think it's less about even the US than about major importer contexts more generally. So to me, a firm, if you're looking at a transnational firm, that firm is not laser focused on what the US is likely to do about something happening in Vietnam, unless that's been in the news recently. What they're thinking is, where are they running risks, regulatory risks in the EU, in Australia, in Canada, in the US? And are there ways to mitigate those risks? And so, for example, as Sophia gestured to in her opener, the EU has just in the past month gotten very close to the final stage of passing its own forced labor product import and export ban. It has also it's at the same stage with an EU-wide corporate sustainability due diligence directive that's both environmental and labor related. Those things will create liability for forced labor for corporations in the EU, whether the US issues 1 WRO next year or 50. And so I think the question is, can we put constructive solutions on the table that will, for me, first and foremost, help workers, and second, that will also give corporations ways to feel that they are protecting themselves in an environment where people are increasingly looking and where there are increasingly economic consequences for violations of labor rights in their supply chains. Maybe I'll stop there and pick up the other questions later if other people don't leave them on, if we leave them untouched in the discussion.